Welcome to Michigan Condo Voices, where real co-owners and real Michigan communities come together. We break down the issues that matter most with clarity and transparency. Let's get into today's episode.
Hi, everyone. This is Stephanie with Michigan Condo Voices. Today, we are reviewing a published decision from the Michigan Supreme Court involving a condominium association. This is part of the Michigan Condo Court Cases Explained series, where we review published appellate decisions to better understand how Michigan courts interpret condominium governance. This case, Janini versus London Townhouses Condominium Association, docket number 164158, addresses an important issue in condominium governance. Can a co-owner bring a premises liability claim against their own association? I'll briefly explain what the dispute was about, what the governing documents required, what the court decided, and the practical governance lessons for co-owners and boards. This summary is educational and based on written court opinion. If you live in a Michigan condominium community, you may have wondered, can a co-owner ever sue their own association? This case clarified how courts analyzed that question. The case involved a co-owner who slipped on snow and ice on a sidewalk located within the condominium's common elements. The association's governing documents assigned responsibility for maintaining common elements, including sidewalks, to the association. Historically, some Michigan decisions suggested that because co-owners collectively own common elements, they could not sue their own association for injuries occurring there. However, the Michigan Supreme Court revisited that reasoning. Instead of focusing solely on ownership, the court focused on possession and control. If the association controls maintenance and repair of common elements, it may owe co-owners a duty of reasonable care, similar to the duty owed under traditional premises liability principles. The court sent the case back for further proceedings consistent with that clarification. Importantly, the decision did not automatically make the association liable. It clarified that a co-owner may bring the claim if the required legal elements are satisfied. This ruling does not mean every accident leads to liability. Associations are automatically at fault, or disputes should escalate immediately. What it means is legal analysis now centers on who had maintenance responsibility, who exercised control, and whether reasonable care was taken. That is a structural question, not an emotional one. For boards, this case reinforces the importance of governance discipline, reviewing maintenance assignments in the master deed and bylaws, ensuring snow removal and inspections are documented, confirming vendor contracts clearly reflect responsibilities, and reviewing insurance coverage and exclusions. Most associations carry general liability insurance for this very reason. If your documents assign maintenance responsibility to the association, your operational practices should reflect that responsibility. Consistency matters. If a co-owner is injured in a common element area, the first step is not litigation, it is documentation and clarity. Here are some questions to consider. What do the governing documents say about maintenance responsibility? Was the condition isolated or recurring? Are inspection and repair procedures documented? And Has the issue previously been reported? The Janini decision emphasizes structure over assumption. Legal rights exist in a framework, and that framework begins with your condominium documents. Here's why this case matters. For years, there was uncertainty about whether joint ownership automatically barred negligence claims involving common elements. Janini clarified that shared ownership does not eliminate a duty of care when an association controls maintenance. Authority and responsibility go together. When associations are given control over common areas, courts may expect reasonable care in exercising that control. Clarity about these roles can reduce conflict and improve prevention. This case is not about encouraging lawsuits. It is about understanding how Michigan courts interpret responsibility within condominium communities. When boards and co-owners clearly understand maintenance obligations, insurance protections, and governance structure, there are fewer misunderstandings. And in community living, clarity prevents escalation. Take care, everyone. Thanks for listening.